I'm Suzanne Tetrault. I've been a communications attorney for many years, most of those years spent at the Federal Communications Commission. I'm here today to talk about what the FCC's rulemaking process looks like. I'm going to cover a few different topics, beginning with what causes the FCC to start a rulemaking in the first place. Then I'll talk about some key legal requirements that shape the process, what it actually looks like in practice, and what happens when the FCC is ready to actually issue an order adopting rules. There are a number of different things that can cause the FCC to start a rulemaking. The first of those isn't really within the FCC's discretion. When Congress enacts communications-related legislation, it often instructs the FCC to adopt implementing rules. Another possibility is that the FCC may receive a petition for rulemaking, which any member of the public can file. The third and most frequent reason that the FCC starts a rulemaking is because it has identified a problem that needs to be addressed or a particular policy that it wants to implement. So for instance, if the FCC is interested in implementing spectrum sharing in a particular spectrum band, that may be a reason for it to start a rulemaking process. There are a number of different legal requirements that apply when the FCC, or any other federal agency for that matter, wants to adopt rules. I'm going to focus just on the two perhaps most important of them. The first is that the FCC must have statutory authority for the rules that it wants to adopt, which is to say that the FCC can only do the things that Congress has told it can do. The agency has very broad authority when it comes to radio spectrum issues, but it must be able to point to something specific in the Communications Act to justify the rules that it wants to adopt. The other overarching requirement is the Administrative Procedure Act, which establishes the basic framework for rulemaking within the federal government across all of the agencies. The basic process is summarized with the phrase notice and comment. The agency has to give notice to the public of what it's proposing to do and accept comment from the public on that proposal. There are very limited exceptions to the notice and comment requirement, and you'll see that process implemented in nearly all FCC rulemakings. So what does that notice and comment process look like in practice? To begin with, the FCC may have discussions with industry or other interested stakeholders before it takes official action as part of the process of deciding whether it wants to begin a rulemaking in the first place. The first official step, though, is to publish a document called a Notice of Proposed Rulemaking in the Federal Register. That's the notice part of the notice and comment process. That Notice of Proposed Rulemaking will explain why the agency thinks a rule may be appropriate, and it'll make a proposal, sometimes very specifically with the text of a new rule written out, other times more generally. It'll ask some questions about pros and cons of that proposal and may ask about alternatives as well. As an alternative to starting with a Notice of Proposed Rulemaking, particularly when the agency has a lot of general questions about what it wants to propose, it can start with a document called a Notice of Inquiry, which is very similar to the Notice of Proposed Rulemaking, but it's not affirmatively proposing to adopt rules yet at that point. So it has to be followed up by a Notice of Proposed Rulemaking if the FCC decides to go forward. Once that Notice of Proposed Rulemaking has been issued, the comment part starts. Written comments are accepted by the agency. They establish a deadline for those comments, which is generally at least 30 days, sometimes longer than that. The FCC also routinely allows parties to file reply comments, which is to say that they can comment on what other people said in the initial comment round. It's also important to recognize that those written comments are not the only public input that happens at the FCC. The FCC allows ex parte contacts, which means that you're allowed to have meetings with the FCC to talk about the proposals. You simply have to put something in the record afterward to identify for the public what it was you discussed with the FCC. That Notice of Proposed Rulemaking is typically the only step required to get to the adoption of rules. But sometimes the FCC will issue a further Notice of Proposed Rulemaking if the comment process identifies additional questions that it would like to have more comment on. Once the FCC has received and reviewed those comments, it has to decide whether it wants to go forward with its original proposal or possibly change the proposal a bit in response to the comments, or potentially even decide not to adopt any rules at all for the time being. If it does decide to adopt rules, it issues a report and order that lays out the specific text of those rules, along with an explanation of why the agency has now decided to adopt them. As part of that explanation, the FCC is legally required to consider and address all of the significant comments that it received during that notice and comment process. So for instance, if someone has filed comments that are opposing what the FCC wants to do, if the agency decides to go forward with it anyway, it has to acknowledge those comments and explain why it has decided that the better course is to move ahead. The report and order is also going to establish an effective date so that everyone knows when they have to comply with those rules. The report and order is not necessarily the last step in this rulemaking process. There are a few possibilities that can inject another stage. One is that interested parties can always file a petition for reconsideration of an FCC order if they believe, for instance, that the FCC didn't fully address the record or that it made a mistake. If the FCC gets a petition for reconsideration, it has to consider that and then issue another order in which it either stays with the original decision or modifies it in some way. Some FCC orders are also subject to the Congressional Review Act, which gives Congress the possibility of disapproving those regulations. That happens rarely, but it does occasionally happen. And finally, FCC orders are subject to court review. They can always be appealed, and oftentimes they are, given the stakes when some of these rules are adopted. Any of those things can postpone the date on which the FCC's rules are able to take effect, and oftentimes you'll see at least a reconsideration or a court review, if not both. Once the FCC has adopted rules, if it later decides that it wants to change them, it has to go through the same steps that I've just described for any revisions as it went through for adopting the rules initially. Thank you.